Hello, I'm starting my tea time live. I'm really excited today because we have Rachel Gillman, who's a family law barrister, and she specialises in all sorts of family law. She's extremely experienced. I think started practicing family law in 1988, she'll confirm. And we're going to be talking about how the court deals with allegations of domestic abuse. So I'm going to go live with her any second. Here she is. Hi, Rachel. How are
Hello,
you?
everyone. Good evening. How are we all?
We're all great. I'm
Good.
so happy that you've joined us. I know you have no social media profile,
No,
and
I
I've
don't.
inveigled you to come on tonight.
Real.
Rachel, tell us about what you do.
Okay. Well, I've been a practicing barrister for 30 years. I was fortunate enough, in fact, to be in chambers with Joe for many years when we were at three Dr. Johnson's. And we've gone our separate routes, but we're both involved in family law. I continue to be practicing. I'm in court every day. Love the advocacy. And anticipate I'll do it for as long as I can. I like the clients. We're very privileged, aren't we, Joe, to be involved with people at crisis in their lives, and we want to deal with them professionally and try and find the best ways forward with the least conflict.
Absolutely. As you know, as we go back years, we were in chambers together. Oh gosh, about 25 years ago, and you do lots of cases for us at Family Law Cafe. And as I say, as you've told us, you're in court every day. So I think that, as I say, I'm really excited that I can ask you some questions, because I feel that on social media there's a lot said about what's happening in the family courts, but you know, those that are practicing day in, day out, we don't often hear from them. So what we're going to talk about today, I think your suggestion, one of the, you know, the really important topics is how the court is dealing with domestic abuse. So just, I suppose, as a starter, where does it all go? When did this all come in, that the courts would deal separately with allegations of domestic abuse?
Okay, well, it did start with a seminal case. We won't bore everybody with case law, but there were a number of experts involved in a really important case in 2000 called Riel, who outlined to the court the psychological effects on children in particular of not necessarily directly witnessing domestic abuse, but being present and being aware of it, and the effect on carers of their non-availability to care for children if they were undergoing traumatic abuse. But it's changed because, Joe, as you know, we're not now talking about domestic violence. It's not limited to violence, physical violence. It's morphed out into a very wide definition of domestic abuse, which covers emotional, physical, psychological, and importantly, coercive and controlling behaviours. And the reason why I think it's so important to talk about it is because the statistics are showing everyone that in 40% of private law cases, and private law cases are the cases between private couples, in 40% of those, there's domestic abuse raised. And those cases tend to go down a separate pathway because the court takes the effect on children of domestic abuse so seriously.
And just to give people an outline, because we're trying to give some practical advice, if one party raises that there's been domestic abuse of some kind, as you've said, there's a wide definition. So let's say a party says there has been ongoing coercive control, and, you know, emotional abuse, financial abuse. How's the court going to deal with that?
Okay, well, at the very first hearing, which is listed before the court, it's incumbent on the court to see whether those allegations are really important, whether they need to be determined, whether they're going to have an impact on what orders the court will make in relation to children, the time they spent with I'm going to call it the non-caring parent, which is an unfortunate term, the parent that they don't live with. We don't use terms such as custody or residence anymore. We use terms such as time spent. And the reason why the court has to consider it at an early stage is because if there are serious allegations that are going to impact on how much time a child spends with the other parent going forward, then there may need to be an assessment of that risk by an independent welfare advisor called a CAFCAS officer. And there may need to be a determination of those allegations.
How does the court deal with that? So let's say, and sometimes there's cross allegations, aren't there? You know, there's a C100 form, and then there's another form, C1A form, where they may make allegations, and we know there's a safeguarding letter. So at the first appointment, there are allegations of domestic abuse. So is it always the case that all of those allegations will be investigated?
Well, it's very interesting you asked that question, because this year, 2022, there's been a really important case called, and again, boring you with case law, but we work on case law, called K&K, which draws back the focus. Are these allegations really, even if they are proved, are they really going to impact orders that the court's going to be invited to make? So sometimes you have a lot of unpleasantness, a huge amount of unpleasantness when couples separate in the immediate phase of separation and in the immediate aftermath. That's often called situational volatility. But if the allegations are far more serious, if people are worried about threats to life, serious control, things that will impact handover of children, will continue to impact the carer, could impact the children emotionally, then the party making those allegations is invited to set them out. And in this case, we used to just set them out, a number of allegations, but in an earlier case, what the court said is they want them in categories, so the court can look at categories of behaviours rather than just numbered allegations. Sorry, my running around some.
Yeah, because there's been a bit of fluidity, hasn't there? Because for years we had what's called Scott schedules, and we had courts saying, look, you know, the 5 main points, and then we had another case, didn't we, a couple of years ago, where it said actually it's not as simple as that. So how?
That's a good question. Yeah. A lot of courts were limiting. They said, okay, we'll hear what allegations you've got, but we're limiting you to 5 or 10. Mm-hmm. That process was discredited in a case in 2021, because controlling coercive behaviours, for instance, are a pattern of behaviours. And if you're limited to a number of allegations, it's very difficult to establish the flavour of it. So now the courts prefer what's called clusters of topics. And they're saying that people should really have unlimited scope to set that out. Not hundreds of allegations, but just a number of allegations that give flavour to that without a numerical limitation.
Yeah. And so if they then, you know, at the first appointment, they've said, put out your schedules. What do you think about people getting representation or representing themselves? What's your thoughts on that?
Okay, this is a really difficult, tricky one, because it just so happens that this year I've had 2 gentlemen who've come to me and said, on direct access, who've said, look, I've got to tell you, I want you to help me with making applications to see my children, but I've got to tell you, there's been findings of fact of domestic abuse. I tried to do it myself, and perhaps that wasn't a good idea because these findings have been made. It's quite difficult to appeal hearings where people have given evidence and the court's heard them firsthand. You would struggle to find an appeal point there, providing the process had been fair. So what I say about representation is think quite carefully, maybe get some initial advice. If you can make some concessions, do so. Because there's no point fighting allegations where you think, well, maybe that behaviour did occur, but I could give a reason, a rationale for why it occurred, and I can set out reasons in the context. So I think get some advice at an early stage, because it's going to have such important ramifications going forward. Yeah.
And so and I think that's true, that maybe people get quite fearful and saying, look, if I admit that, that's going to have this consequence. But at least you could get legal advice, couldn't you, and say, yeah, I behaved in that way. My feeling is what the courts are looking for, obviously they're looking for safety of children. So sometimes none of us are perfect. Making an admission you have done something wrong, but finding a way then to take help and get help and change, then that could be okay, couldn't it? I think people get very, yeah.
So if you're going to make admissions, supposing you did have an altercation, a physical altercation, or supposing you did use abusive language, you might feel, well, that did happen, I can admit it. You might want to couple those allegations with showing the court that you're taking measures to address those behaviours. You could perhaps do an online parenting course. We're all in need of as much help as we can get with parenting, but that would show, first of all, a good grip on reality, an honesty, and a willingness to address the underlying issues and change. So I always say when people come early, get onto a course for not necessarily domestic abuser, but maybe a parenting course. There are a whole range of courses that you can join. The other thing, Joe, is that the case that I mentioned was one that really shouldn't have gone to fact find. And that's the barrier. K&K shouldn't have gone to. The reason it shouldn't have gone to fact find is because the mother in that case, in her C1A, and your participants will know when you make an application, it's a C100 or C1A. She had said, I'm not opposed in principle to unsupervised contact. And after a few months, there was some unsupervised contact. It was only when the matter came to court and the mother spoke to welfare officers and outlined the seriousness of some of her allegations, which include allegations of marital rape, that the case went down a fact-finding route. But by the time it was appealed, the court said, well, if the mother was at a position where she felt unsupervised contact was possible and could be done safely, then we really shouldn't have expended all this time and energy, in having fact-finding.
Yeah, I think that sometimes it feels that cases get quite lost with different judges and different tribunals. And you and I will know that we'll look at one case and it could be quite similar facts and they've gone different ways. Do you have that happen to you?
Yeah, absolutely. Depends on the judge. Some judges will, I think I used that expression a little earlier, situational abuse. Some judges will accept that. Some judges will reject that and say any abuse is so serious. And depending on the allegations, we have to think about fact finding. The other thing that is happening is this, that if you make allegations of domestic abuse and indicate that you want fact finding before decisions can be made, and you want somebody to do a risk assessment, typically of the father, that has the effect of delaying things. So if you're refusing contact and you make these allegations, some of these mothers, obviously they have merit in their allegations, but it can be used as a tool to delay. It has been said, sometimes fathers will say to you, you've probably had this, Joe, it's the mother that's alienating these children from me, and she's using these domestic abuse allegations simply to delay and thwart their relationship with me. So there's all sorts of issues going on. And the key things are, if you can make admissions, reasonable admissions, make them. If you can be seen to be addressing your behaviours, do so. Don't make admissions if they're not true, obviously. Think about whether you really need to make counter allegations, or if there's no point having a tit for tat exercise. And also, if you can address with the court whether a fact finding is really needed. Whether in fact, having gone down that route and got to findings, are they really going to be findings that are going to stop you seeing your children? Or could the court contemplate you seeing the child in a contact centre?
That's a key hearing, isn't it?
Sorry, Jen.
Yeah, I'm coming in there because I think that hearing, usually what happens, because we're going through it chronologically, we've had that first hearing, we had the schedule of, or as you say, the allegations put in their general categories. And then there's usually a hearing, isn't there, where the judge will go through, should there be a fact-finding hearing? Because then that will have crystallised each party's case. And it seems to me that that's a really important hearing, isn't it? Because often a judge will say, okay, that may have happened or not happened, but is it going to affect the order the court is going to make? And that's a crucial thing to remember. Is it going to affect contact with the child? Because people do bad things to each other. That doesn't necessarily mean that contact will be affected. It just depends, doesn't it?
It does, and that's where the battle lines are, really. You want to be able to try and persuade the court, if you're facing these allegations, that they can be dealt with through some other means. They don't need to go to full litigation with evidence, delay, etc. That you could perhaps agree to some supervised contact to start off with, or you could agree to a third party assisting you with the handover arrangements. So you could be putting something forward and saying, look, this mother isn't really suggesting that I never have contact with my children, have a big delay, or I could only write to them, or that my conduct is so serious that they shouldn't be having a relationship with me. I can put forward these alternatives that I'm actually prepared to contemplate.
Yeah, I mean, I can see a comment coming up that someone has not seen his son for over 1.5 years. I have a court date. I've got more full statements. One of the things that I find is that it's really harmful. You know, we're not getting into here, are we, you and I, whether something's true or whether something's false. We're getting into the process, but the process can be really damaging, because you can have, the court says, okay, put your allegations, and you have another hearing of different allegations and different allegations. And to me, that just makes no sense at all. Either a party is saying this has happened and this is relevant, or party isn't, and there needs to be a very full analysis. I mean, is that
Well,
what do you think about?
Because I'm in fact dealing with the case where exactly this has happened. There's an incremental, there's something funny going on where we constantly get new allegations cropping up. And I was at a directions hearing, and the mother had raised an attempt to strangle. And I said, it's far too late to add that. And it was said, well, the nature of domestic abuse is that it takes a long time for you to process. And she saw a counsellor, and she came to terms with that herself, and it should now be litigated. And the judge thought very hard about whether to allow that to go forward, given that it hadn't been raised at the same time as the other allegations. In fact, in our case, she did allow it, because she said to me, well, you can challenge the credibility of it and the delay when you ask her questions. But it's not very satisfactory. But that doesn't happen very often, that you, having committed to a Scotch schedule of allegations, you're allowed to add. I think I can reassure, people that they would need the leave of the court to do so, as happened in that case. Otherwise, there's no end to it.
Otherwise, no end. And obviously, let's move on to how that fact-finding hearing will work. Give me some of your experiences, because you're doing this day in, day out. And I know that, for a fact, things don't always work in the way that everyone thinks they're going to. Am I right?
Yeah, absolutely. Well, the first point is there is a rigorous assessment of the evidence by the court. So people that are worried about false allegations, that they need to know that courts do strive to be fair, and people are given an opportunity to put their case. I think sometimes the problem is that people think they can just go along and say, no, I didn't do that. And the other party may have produced complaints to police. They may have reams of crisp reports from police to show allegations have been made, even if they haven't got charging decisions or cautions, etc., etc. So you need to be prepared, and you need to put in a really good statement before you get to court. There'll be a direction at some stage. The person that makes the allegation goes first. If you're responding to the allegations, you go second. So you can respond fully and you can see what evidence they've got. And you shouldn't have to respond until you've seen all of their evidence. And that should include the police evidence. The courts can order disclosure of police evidence. Then you turn up at court and you've got the time allocated. Person making the allegations goes into the witness box and gives their evidence on oath. And this is where it gets tricky. You have to, or your barrister has to cross-examine that witness. That's quite a skilled task. It's difficult, particularly if you're doing it in person and you're emotionally involved. Formulating, really closed questions that get to the truth is quite a tricky area of expertise.
So Rachel, I want to butt in because someone's made a comment, and this is the nub of it, isn't it? What if they can't afford legal representation? What are they to do? What's your view?
I think this is a really good question. It's really unfair if you think about it, because another thing is that if you are involved in a private law dispute that's between parents over children, normally you don't get legal aid. But if you raise allegations of domestic violence, you can do in certain circumstances if you've made a complaint to the police, if there's a live complaint to the police, if the other person has been cautioned, or if you've made an application for family protection under the Family Law Act. That's injunctive relief, which is a whole other issue. But I'm sure most of you will know that you can get injunctions regulating people's behaviour. So if the person's making those out, if she ticks any of those boxes, she mustn't be sexist, or he can get legal aid. And the person responding, you'd think, well, they will as too, but they won't. Just because you're responding to allegations of legal aid, it doesn't mean you will get the funding. And I feel every sympathy with the person that's asked this question. So
yeah, Rachel, you'll know that one of the reasons with Family Law Cafe, I'm trying. We're a business, so we get barristers in, and people will have to pay. But I'm trying to encourage barristers to kind of be realistic. It's difficult because of the lack of legal aid. There isn't a huge junior bar, and it is expensive, but the fact-finding hearing is very important, isn't it? And I think I'm right, isn't it?
Will stay with you.
Yes.
I have had equally. I've mentioned the two people this year that've come and said, help me now. The fact findings happen. I did it by myself, and it all went wrong. The judge believed her, and I wasn't very good. I felt tongue-tied. I was against a barrister. I felt there was an inequality of arms. I have also, I should be fair, had clients who've done a very good job. But you have to plan it as if it's a military campaign. Go through their statement line by line by line, and think about a question whereby they can't just pontificate and make the allegation worse. That's the skill, isn't it, Joe? Asking questions that don't come back with more stuff, and they sound more credible. And you've got to put in really good evidence of your own. So it may be, if you've got really limited means, it may be getting some assistance with case preparation for that hearing. But that hearing is really...
Another thing I suggested, and it's something I just throw out there, that I've had cases where we've got in criminal barristers whose fees, they're really good at cross-examination. So it's something that I've just thrown out to say, you might not be able to find a family law barrister, but remember, it's pretty much like a criminal trial. So you might find a junior barrister who does crime, and obviously they might not be willing to do it, and it would be direct access, but you might find someone junior who will just come in and do the cross-examination. I think it's just an interesting point. They won't know about family law, but they might be able to analyze the discrepancies. It's just something to think about.
Yeah, or go through an organisation like Family Law CAF and ask for some advice on the paperwork and an honest appraisal of whether these allegations are so serious that you need representation. I think after K&K, we can assume that if the court has set a fact-finding in process, then it is serious. the other option is to approach the bar by way of direct access and get an early appraisal from a barrister directly. But Family Law CAF, and I think you're the only person, Joe, you're the only organisation offering that kind of appraisal.
Well, we're trying to give a sort of, you know, buy in what you need. I mean, obviously you can ask advocate, that's, you know, when people are acting pro bono, but I know a lot of people go there and obviously, you know, their services in really high demand. And but then just
representation unit. Well, I was just going to say there's the free representation unit as well. Mm-hmm. Some of us do those sort of cases occasionally. I know people in chambers will pick up free representation unit cases. So that's something worth approaching.
Yeah. And I mean, on the other side, yeah, sorry, yeah. Carry on. No, I mean, on the other side, we act for mothers, don't we? And it is generally mothers making allegations, and, you know, we will.
But they will get legal aid. This is the point. Yeah. They will get legal. If you're making a whole host of allegations, as long as you tick one of those boxes, you've met, you know, and this is a worry because sometimes, in order to get funding, so let's suppose you're a mother and you've met somebody else and you've moved on and you're not keen to give the father the level of contact that he wants. It might be the case that you might raise allegations about behaviour, and as long as you've made a complaint to the police or you've gone down the route of seeking a non-molestation order, you will qualify for legal aid. So that they're okay. And I'm not minimalising those concerns at all. I'm not saying that's wrong. I'm just saying there's a bit of an imbalance in my view.
And I think now that because of the change in the law, any questions of the victim need to go through the judge, don't they? You can't ask them direct. Has that come into force now?
Yes, that's coming in. That's they're thinking about getting specialist advocates to ask victims of serious assaults somebody else in. So that's going to add another layer of complication. And as you know, Joe, we're already seeing on a regular basis special measures for victims in court. So if there are people listening that feel that they might need to separate and they might need to raise these concerns, the courts are very sensitive to the system being used by a respondent abusively. So there are special measures such as screens and special waiting areas and special entrances. This case I've got at the moment, where there are special measures. So that the husband who I represent, he's never within an eye shot in the courtroom of the mother, and she can give her evidence without him looking at her. So, you know, I think it's exploded within the last 5 years, rightly so, because as I say, the court process itself can be abusive for those persons making the allegations.
And in terms of after the fact-finding hearing, obviously the judge will make a decision. Let's say there are a number of allegations. Can you explain what will happen after that?
Yeah. Okay, the purpose of the fact-finding hearing is so that there is a factual basis to move forward. For assessment, the next stage is assessment by CAFCAS, and they receive those findings and make recommendations as to what should happen next, make recommendations as to whether the perpetrator, because if those findings are made, you've got somebody who has perpetrated a serious assault or controlling and coercive behaviours or emotional abuse. And they might recommend a domestic abusers prevention program to that perpetrator, or parenting work, or they might recommend some sort of supervised contact where there's a note taker and there's provisions for safety in bringing that child to that centre so that those parents don't come into contact. So that's the process post the findings. And another reason why it's important to think about representation if you're facing allegations is because those, as I've said, those findings stay with you. And those findings are made on the civil basis of proof. So it's more what the judge just has to decide. Is it more likely than not that mum's telling the truth on this? It's not like going to a criminal court and you're having to show, it's beyond reasonable doubt. It's quite a low threshold for the court to. The court's really just got to think, I prefer this evidence of this person to this other person.
Yeah, because I think some people think that, oh, this person had no evidence, but obviously giving testimony is evidence, and 51%, that's a finding. And because we know that these allegations may come to a criminal court and someone could be acquitted because it's beyond reasonable doubt, and the same allegation would be heard in the family court and would be found proved, because it's more likely than not. It's a different test, isn't it?
Yeah, I think people would be surprised to hear that, let's take the stereotypical mother making an allegation of, let's say, marital rape. It goes, there's a decision by the CPS to prosecute it, there's an acquittal. I think people would be surprised to then hear that the same allegation had been relitigated in a family court, because the different standard of proof, there may have been a finding that it did happen. And that's a binary decision. The judge in the family court decides either it happened or it didn't. And if he decides it happened, that's what everybody takes it to have happened thereafter. But those two jurisdictions, the criminal and the family, run separately. There are provisions for judgments to go between criminal courts and family courts. But the family court, my experience is that family judge receiving an acquittal from a criminal court don't actually take much notice of it because of the different standard of proof.
Yeah. And once the findings have been made, I often find there's a real difficulty with, let's say it is a father saying, I don't accept that. And obviously we as lawyers saying, I understand that, but now a judge has found that you did do that, so that is now the truth, isn't it? That I find that's a real,
whether you like it or not, the court's made that decision, and as I said, it's a binary decision. Once it's had a hearing and a judge has determined it's happened, every professional involved in your case thereafter will assume that it did happen. That's what they're told to do. There's a finding of the court and they're told to work with that. That's why we've had that process of fact finding. There are as I said earlier, there's very limited circumstances in which you can appeal. You'd have to show a procedural irregularity, or that the judge had just ignored really important evidence, or had done something that was just plainly wrong in his or her assessment of where the truth lies. It can happen. I have had fact finds that we've appealed successfully, but normally we've shown, a really gross error of judgment, leaving something out or not taking into account something that should have been taken into account, and given far more weight. So
I'm smiling there, Rachel, because I've had one appealed. So I always tell people you can't appeal them, but you and I have. But then we're a bit different.
Successful appeals from fact finds in quite a long time. So that might indicate how difficult they are. You've got to fight them while you've got the chance, and it's difficult if you're facing a whole schedule of allegations. It's difficult to come out of those unscathed. You can do. But that's where the evidence gathering for your case and the really nuanced and careful cross-examination of the person making the allegations comes into play. You can also, of course, call on other people to give evidence on your behalf. Other family members, obviously they're biased towards your case, but they can often be very, very, very helpful. For instance, if a person says, well, throughout the relationship they were abusive, but you had somebody living in the house, a lodger or a third party would visit regularly, they might say, well, things were rather different from my point of view. That evidence will have some merit. But Jo, as you say, you're right. People often say, well, there's no corroboration. How will she get that allegation through? But there doesn't need to be. If somebody's evidence is what they say on oath in the witness box.
I think it's why it's really tricky, because by the very nature of domestic abuse, it's why it's really harmful, because it is behind closed doors. And obviously, if it happens, then it may not be believed and it's happening. On the other hand, then people have to understand that a court can listen to both witnesses. It might just be he said, she said, and the judge prefers the evidence of one party. And this is something that people, I think, instinctively find it difficult to grapple with. It's not like a criminal case where, a judge and jury would sit there and there would usually be some corroboration. Often there's not any corroboration at all, is there?
No.
I mean, there might be some peripheral, then people would challenge that. It was reported to the doctor and then say, oh, it was a fake thing. It's a very tricky area, isn't it, to say the least?
I think, though, sometimes that can assist. If there were systemic abuse of somebody, you might expect, if you were representing the perpetrator, you might say, well, it is odd that they've never mentioned to a family member or a GP anything about it, and there's been no problems with the children at school. They haven't presented as withdrawn. But it's another one of those complications, isn't it? Because it's widely assumed that it is behind closed doors and that people don't speak about it.
Yeah.
So, yeah, you're right. It's often not very profitable to say, well, you didn't make complaint at the time. You have to look for other ways in.
So moving on, there's been findings. There's a welfare report. We talked about domestic abuse programs. There's some difficulties, aren't there, with these domestic abuse programs? Is that something you're experiencing? Something I'm definitely seeing.
The difficulty is, let's suppose you're the perpetrator or alleged perpetrator. You've had a fact find. The court's very definitely made findings that you've been physically abusive, verbally abusive. You put somebody in fear of abuse. Let's suppose there's a whole raft of allegations that have been proved. The judges preferred somebody else's evidence to yours. The CAFCAS officer then will come and see you, and you're expected to respond to those findings. And you're in a bit of a bind situation, because if you say, well, I don't accept that any of that happened, then the report comes back. I talked to him about the findings, the judge's findings, and he rejected them entirely. And that can count against you. That CAFCAS officer might say, well, there's no point doing a domestic violence program because this individual won't acknowledge any of their past behaviours. It's going to be a waste of time. I have to say, Joe, the thinking is changing a little bit on that, because it's a bit artificial to expect people to say, yes, of course I did it all, and I denied it at court, just to see how things went. And I think courts, I've had a few cases where I've said on behalf of fathers, findings have been made. It's artificial just to expect my client to say, yes, I did it all. But judge, he is willing to go on this course and learn about domestic abusive behaviours, and let that information sink in. It might lead to some change in attitude, certainly, and thinking. But I certainly don't have instructions just to admit everything, but I've got a client who is willing to learn about these things.
Yeah, I find that it's a really difficult stage, and I think it's just in state of change all the time, really. So different things have been said in that area, and it would probably take another half an hour just to talk about what's going on there. But it is, it's just one factor, isn't it? A lack of admission is one risk factor. So it's then looking at the risks, isn't it, after the findings have been made? Because sometimes there could be a number of findings, some of them are made, or just one of them. It's until you've had the findings made, then I think my personal view is that whole area and what do we do after is in a stage of transition. But I don't know if that's your experience.
I think it is, because as I say, at one stage, if you didn't say, well, the judge has made the findings, I accept what the judge says, that would be a problem going forward. Now courts are much more open to the fact that people are going to take time for those findings to sink in. They might not just say, yes, of course, I did it all. But as long as you show a willingness to work with the professionals, the courts are far more willing to sanction you going on a course, or, you know, accepting that you're not just going to make an admission just because there's been findings by the court on a balance of probabilities. As Joe says, 51% versus 49%. It could have gone the other way. And judges will accept fathers who say, I'm more than, I can't accept the findings. And I've had cases where fathers have said, I don't accept the findings, but I am willing to listen, go along and listen and participate in work. Or I am willing to go to a contact centre and pay for sessions, even though I don't think it's necessary, just so I can prove that I can adhere to strictures and rules. And lots of my fathers have said, you know, it's just crazy that I'm having to go to a contact centre, and that's being proposed. You know, before we separated, I was jointly caring for my children. That's just absurd. But I've had to say, well, findings have been made and we've got to build this up gradually. You've got to grab anything you can, because from the children's point of view, they have to be seeing you in whatever circumstances.
Yeah, and we have to come back to the whole purpose of this is not, these are not criminal findings, so no one's going to prison or being punished in a criminal court. The court's saying what's safe for the children, what's the appropriate arrangement. And so obviously that's going to depend. So if they found that, let's say, emotional abuse or psychological abuse, it's going to, you know, whatever has been the findings, the court is looking for safety both for the child and for the carer, the main carer. So, you know, that's what we have to remember and hold that in our minds, isn't it?
Yeah, I mean, we're dealing with some quite extreme cases when they go to fact find, and I do think that the change that's going to come about in the court system is we're only going to have these fact findings where things are really serious following Re-K. You know, they really do impact on the future, whether contact can be safe or not. But I've just finished a case where the allegations are really serious, terrible abuse, etc., etc., where the local authority actually wanted an order. The local authority are involved because it's so serious, but we still have a fact find. And they were asking for an order that actually said there shouldn't be any contact. It's called a no contact order, which would have made it very, very hard for my client in future. But we successfully argued, and I'm sure a lot of people participating in this call will balk at the word successfully, but we argued that there should be an order for indirect contact only, so at least a line of communication was kept open, albeit through letterbox contact. They can have a PO address, this couple. But I have to say, in that case, the allegations against my client were very serious physical assaults, series of physical assaults. So, and threats to kill.
Yeah.
I felt that was a modicum of success, where what was being proposed was an order for no contact, that we're going to have indirect contact. And the judge has said that if my client goes away and addresses behaviour, he can apply back at some stage for a review. And she's also put mechanisms in place with the local authority who are involved, so they can review and see whether progress can be made from indirect contact. And he said to me, well, what good is that, indirect contact? I said, it's really about the children at this stage, not you. They need to know that you care enough to be writing to them. And even if you don't get anything back, you just keep with this, and you take some steps to address things that have happened in the past and your behaviours, and we'll come back and make an application in due course. And that's in quite an extreme case where the behaviours were really life-threatening.
Okay. Any parting thoughts? Because there's been a lot that we've discussed and it's a deep subject. I'm sure some of the people that have dropped in, I've seen some of the comments, when you're involved in it, I think what I would throw out there is every case is different, isn't it? And you can be involved in a case and I'm guessing would feel very isolated, very lacking in support. And I know that there are organisations out there that, you know, you can, if you can't afford your legal fees, I would encourage people to join organisations where perhaps other people can give you a little bit of support. What are your thoughts, Rachel?
Yeah, there are very good organisations that people will know about that support fathers. If you Google, I've done talks for those sort of organisations, and they're really committed to offering support for fathers. We've talked a lot about the perpetrators, but they're the and forgive me for that, because there'll be people listening in who are mothers with, you know, real concerns about their partner's behaviour. So it's just that the person on the receiving end of these allegations seems to have less support. We've talked about that a little bit. So Google for support groups for fathers. They're really well informed. They have barristers and lawyers that advise them regularly, and they're really well prepared to assist people that can't get legal aid to defend these allegations. The other thing is just to take the allegations seriously, of course, look very carefully at what's being said. And we've talked about that first appointment where you say to the court, yeah, they may appear to be serious, but, you know, if you drill down, they were arguments between us that were in the context of our separation. And, you know, I'll be able to, we should be able to persuade the court that we can move on without the need for resolution of facts. There's also, interestingly enough, in that case of K&K, it's also mentioned that there's, you can, if you can attend a MIAM, you can attend, I was interested to read, you can apply for a voucher to receive up to $500 cost of mediation.
Yeah.
Now, I haven't had any client that said to me, I've done that, but that's something that is available. And hold out for mediation. Say, I'm willing to go to mediation.
I mean, I think there's a big push. Sorry, carry on. Yeah, carry on.
Yeah, I'm going to say, even if the allegations are quite serious, say I'm willing to, I'd be very happy to mediate, even if we weren't in the same room and we had a mediation.
Shuffle, yeah, because there's a bit, the courts know that there's a big backlog, and they're trying to get out of court ways of dealing with matters. But I suppose just to finish, and just for everyone to remember and focus, that this is about what are the right child arrangements, and is there something that should take it out of the norm, you know, that is, those are the allegations the court has to explore.
Yeah, the whole purpose of this is not just to beat people over the head for their behavior during the course of a relationship. It's to really drill down, focus on the children. How are things going to work out for them? Are they going to be cared for? Because in some cases, you know, you've got to think, is this child being cared for by a mother who is so afraid of her partner that she isn't emotionally available to them? It's not just a question of them having suffered psychological harm by witnessing or hearing domestic abuse, or domestic abuse being directed at them. There are ramifications for family life of severe domestic abuse, and that's why the court takes this so seriously, and that's where the change has been over the last 20 years. Well, we were talking about that seminal case of Riel, when a body of psychiatric experts were saying, you know, the courts are just missing the point here. It doesn't have to be extreme violence. And then things have progressed over the last 20 years. We've had protocols, and we've had a practice direction that says you really need to take these allegations seriously. And it's almost been that the pendulum has gone too far, taking every allegation, but it's coming back a little bit, so that there's a robust analysis of, you know, what is the purpose of this exercise of having a very close scrutiny of people's behaviours during their marriage or during their relationship, or what other avenues can the court go down. But at the heart of it is, how do we keep children safe from physical and emotional and psychological harm in the fallout when their parents separate and they've got to communicate to arrange relationships, ongoing relationships.
Rachel, could just chat away. I'm really, really grateful that you've come on. I hope it wasn't too traumatic for you, dragging you onto Instagram and making you open an account just to get you on here. I hope that was useful for those listening, lovely to speak to you as always. And obviously, Family Law Cafe, any queries you have, send a direct message, give us a call. We have wonderful people like Rachel who, you know, your case may be one that she deals with, and we have lots of other experts. But yeah, thank you for that deep dive into, you know, what's just currently happening in that area. And thank you very much.
Thank you. All
See
the best.
everyone again on Wednesday.
Bye now.
Thank you, Rachel. Bye.
Bye.